Thank you. Mr. Schweitzer, let's go to you first. I want to talk about surrogacy arrangements. How could commercial surrogacy arrangements involving foreign clients, particularly if facilitated by foreign government political elites, end up creating a long-term national security risk for the United States?
Well, you have the reality that if you're granted citizenship and your father is, say, a high-ranking CCP official, you will certainly have the opportunity to vote in elections, apply for government jobs. I think it creates an ambiguity, right, problem of where is the commitment. So that's the security issue. And when you're talking about the scale of numbers, whether it's the Wall Street Journal case or the case in Southern California, you're talking about large-scale numbers. That's the concern.
Right. Burrowing into the United States through people who would become citizens. All right, let's shift gears for a minute. Mr. Cooper, in Wong Kim Ark, frequently cited, of course, by proponents of automatic birthright citizenship, the Supreme Court seemed to suggest that domicile was sufficient to render a person subject to the jurisdiction thereof, meaning of the United States. But wasn't the domicile at issue there, the specific type of domicile at issue there, a type of lawful permanent residence, as we might put it in our parlance today, wasn't that a little different than what we're dealing with here? And wasn't that sort of uniquely probative of allegiance and consent of the sovereign? And if so, doesn't that make it inappropriate for use here?
Absolutely, Senator Lee. Wong Kim Ark's holding was clearly that a lawful permanent resident, the Chinese individuals, immigrants in that case, were entitled, their child was entitled to birthright citizenship because they were domiciled. The word domiciled appeared about 20 times in the opinion, and the question presented, which the court articulated twice verbatim, assumed in the question that the individuals, the parents, were domiciled lawfully, and that is with the consent of the sovereign.
So they weren't looking at it for purposes of determining domicile for purposes of federal diversity jurisdiction or something like that. They're using a different meaning than what might otherwise be attached with that term.
The traditional meaning in the law of nations, Senator, that is to say, the place where that is your home, the place that where if you leave, you intend to come back. You never plan to leave.
Right.
That's your domicile.
So in that respect, isn't it true that illegal aliens fall outside the holding of Wong Kim Ark, such that that case avails them of nothing if they're talking about a different term?
They plainly fall outside of Wong Kim Ark. Illegal aliens are by definition not lawful permanent residents who are domiciled in this country.
Right.
They are here in defiance of the sovereign's law, not with the consent of the sovereign.
Now, Professor Frost, would you agree with that fact? Would you agree that the individual in Wong Kim Ark was, as we would put it today, a lawful permanent resident?
No, the individual in Wong Kim Ark was born in the United States and he's a U.S. citizen.
Okay, but would you suggest that the holding of Wong Kim Ark is relegated to the facts of the case?
No, the holding of a case is the rationale that supports the judgment. And in Wong Kim Ark, the Supreme Court, the majority, said it applied to people who were here for business or pleasure. Chief Justice Fuller, who dissented, described the majority's opinion, he didn't like it, as giving citizenship to, quote, children of foreigners happening to be born to them while passing through the country, end quote. So everyone understood the rationale of this decision applied to everyone born in the United States.
Mr. Cooper, what's your response to Professor Frost?
That was the dicta of the decision, to be sure. Professor Frost is right about that. And Chief Justice Fuller and Harlan, the sainted Justice Harlan, objected to the dicta in the case, not to the holding of the case.
So John Marshall Harlan I was pointing out, among other things, that this dicta went further. The dicta was a problem.
Went further and said that if this adoption of the common law jus soli theory of subjectship was actually adopted in this country. It was adopted by that majority, not by those who authored and ratified the 14th Amendment.
Right, right. And of course, the precedent has to be limited to the holding, otherwise it is dicta. And the holding in this case dealt with an individual who satisfied this definition of what we would think of as a lawful permanent resident, did it not?
That's right.
Okay. Thank you, Mr. Chairman.